will also greet me. But now that I have this opportunity, can I also greet the co-chairs? Chairperson, thank you.
Yes, I speak on their behalf.
Yes.
At least as far as greetings are concerned. Let me just make a disclosure. I mentioned to counsel in chambers that me and you are well known to each other. And Dr. Maema.
Yes, Chairperson.
As we all live together as practitioners, as judicial officer, you appearing before me in the Northwest, in Mabatu.
Indeed, Chairperson.
And I thought that it is appropriate that I make this disclosure right at the beginning. I mentioned to counsel in chambers, and no one is opposed to me presiding and hearing your evidence this morning.
Thank you, Chairperson. I must also mention, Chairperson, as you do so, that Advocate Nkabinde is also known to me. When I did pupillage the last year, he was one of my co-lecturers in legal writing. So you're not the only person that is known to me. He is also known to me. Advocate Chauke, of course, is my colleague. I would know him. Yes. Thank you, Chair.
Yes, I thought that from the angle of the panel,
yes,
it is proper to make such a disclosure. Advocate Nkabinde did mention in chambers that he knows you to the extent you have mentioned, and we all understand that. He is excused from being here this morning. He is busy doing some work in the evidence leading team's chamber, but he is in the building.
Thank you, Chairperson.
That said, Advocate Ngcukaitobi, I think it's appropriate for me, Advocate Chauke, to verify whether you will take the oath, administer the oath, and or do the affirmation.
Chairperson, I will take the oath, and Chairperson may indicate that I prefer to stand when I take the oath.
Yes, you may do so. You may stand up. Thank you, sir. Advocate Maema, do you swear that the evidence you are about to give will be the truth, nothing else but the truth? And if so, raise up your right hand and say, "So help me God."
So help me God.
Thank you, sir.
Thank you, Chairperson.
Advocate Ngcukaitobi.
Thank you, Chair. Advocate Maema, in front of you, you have your statement, which is page 121. Is that correct?
That is so, Counsel.
Yes. Now, it starts at paragraph 1, just describing your positions that you held in the NPA. Can you, using your own words, describe that?
In my answer, I'll be addressing the Chairperson, so I will say Chairperson.
Indeed.
Yes. Chairperson, I am an advocate who was formerly in the employment of the National Prosecuting Authority in the capacity of a Deputy Director of Public Prosecutions. I was attached to the Office of the Director of Prosecutions in the Northwest Division, which is based in Mabatu. The office is situated at Mega City Complex, East Gallery 3139 Sekame Road in Mahikeng.
I beg your pardon. May we all put our cell phones in silence? Thank you. Advocate, you may proceed.
Thank you, Madam Chair. The statement that we have in front of you does contain your signature at the end, at page 1 to 139, dated the 11th of February 2026. Do you confirm that?
I confirm that, Chairperson.
but it is not sworn. Is that correct?
That is correct, Chairperson.
Can you swear that the contents of those statements are true and correct and they are binding on you and your conscience?
Chairperson, I have read the statement. I do confirm that I know and understand the implication of the oath, and I confirm that I do take the oath.
Yes, but I need you to swear that the contents of the statements are true and correct and they are binding on you and your conscience.
I do, Counsel. I confirm the contents are true and correct, and they are binding on my conscience, Counsel. Thank you.
Thank you very much. Now, I want to then skip those next passages up until paragraph 6. The statement is supported by some 900 pages odd annexures. I just wanted to confirm if you were involved in the collation of those annexures, you've read the annexures, you understand the annexures.
Indeed, Chairperson, I have.
Yes. Thank you very much. Can we then go to the statement proper? It starts from paragraph 7, 8, 9, 10, 11. Let's stop there for now, tracing your history. So just feel free and take us slow. Tell us about yourself, not from primary school, at least from matric. Yeah.
Chairperson, I matriculated in Tulare High School in 1981. Tulare High School is in Lebotlwane. Lebotlwane is in the Moretele district of the Northwest Province. And then I continued to study a BProc and an LLB degree at the University of Fort Hare in 1989 and 1991 respectively. I continued to serve articles of clerkship at the firm of attorneys which was doing predominantly criminal work. It's called Boerder WC and Kruger Attorneys, which is still in Johannesburg. I commenced my articles in November 1991. That is immediately after...
Is that the famous BDK attorneys?
The famous BDK, yes.
If I may advocate Ngcukaitobi, I know that most of us are commissioning officers by virtue of the law. But you may consider later, just for completion, so that when the record is sent to the President at the end of this inquiry, he should be having a complete picture. You can have the statement commissioned before a commission of oaths.
Thank you, Madam Chair.
I know that he has now testified that the contents of this are correct, and he aligns himself with everything that is in this statement. But I suggest that you can later then cause the commissioning to be done and then file it of record.
Thank you, Madam Chair. Yes, we will discuss it with our learned friends if they have an objection to a commissioning after signing. Because sometimes these commissioners will insist that the commissioning and the signing happen simultaneously.
Yes. Maybe we should just verify with you, evidence leaders.
No, Madam Chair will not have an objection.
Yes, ordinarily one could even do it right away. But I prefer that it is done by someone else. Later in the day, you can do that.
Thank you, Madam Chair.
I suppose Advocate Halley, you have no objection?
There
can't be any objection. Yes, let's do the right thing so that we give the President the record that is fully complete.
Yes.
Thank you.
Thank you, Madam Chair. We are still at paragraph 8, Advocate Mayema, where you say that you did, after your LLB at Forte in 1991, you did articles of clerkship at BDK attorneys.
That is correct, Chairperson.
Yes, carry on.
Then, as I was indicated, BDK is a firm that is being predominant. My apologies. I will leave it on, Chairperson. BDK is a firm of attorneys that does predominantly criminal work. Towards the latter part of my articles, as I was working closely with prosecutors in various courts, I developed an interest to become one. And I applied, and I was appointed a prosecutor. I started in Fort Beaufort in the Eastern Cape on the 8th of March 1993. Fort Beaufort, Chairperson, is a small town in the Eastern Cape, fairly rural. It's a farming town.
Yes, you don't have to convince me.
Yes.
What do they refer to it as Bofolo?
Bofolo.
Yes.
They call it, they say emakizeni.
Well, that part, I'm not sure, but the people from Fort Beaufort will be very upset. There's a mental hospital there. That's how it ended up being as a magazine.
Yes. In fact, communities get a service at that hospital, which is very important.
Yes, and then you, from March 1993, you are prosecuting at Fort Beaufort. You then gain experience in Port Elizabeth, Grahamstown, and King Williamstown. Is that correct?
That is correct. What happens in the Eastern Cape is they pick their prosecutors that they identify, and then they expose you to various work in various districts. So I started although being a district court prosecutor when I started in Fort Beaufort, when the regional court would come and sit there, and a prosecutor from Grahamstown would not be available, I would then deal with their regional courts. That's how then it started. That I do the regional court in King Williamstown, in Grahamstown, as well as in Port Elizabeth.
And then at paragraph 9, you then get admitted as an advocate. Can you just explain that? Because you've already been working for 2 years by this stage.
As I was working in Grahamstown, I then received a call from one of the deputies in the Johannesburg office, who saw that I am from Johannesburg, but I'm working in Grahamstown. And then I indicated an interest to come back to Johannesburg. On the 3rd of May, I applied for my admission as a advocate in the High Court. I was then admitted in the then Witwatersrand local division, which is now South Gauteng. And then early in May, I think the 5th of May, I joined the Office of the Director of Public Prosecutions in Johannesburg as a state advocate. I worked as a state advocate, as a senior state advocate, in the DPP office in Johannesburg until the establishment of the National Prosecuting Authority in 1998. When it was established, the first national director, Mr. Bulelani Ngcuka, established what we called the Human Rights Investigative Unit. This unit was intended to look at the cases that came from the TRC. It is the predecessor of what later then came to be called the Priority Crimes Litigation Unit at the NPA head office.
So just before you proceed, I mean, I'm not sure if the statement contains an error or you made an error, because it refers to Grahamstown there as a state advocate, but you are saying you were actually in Johannesburg.
I started as a state advocate in the DPP office in Grahamstown.
Oh, I see. Okay.
Yes.
So there's nothing wrong with the
There's
statement.
nothing wrong in the
Okay.
in the statement.
Okay.
And that is why I think what happened was a deputy in the DPP Joburg spoke to a deputy in Grahamstown and said, "But this name is known to me."
I see.
And then that's when Kevin Edwell then phoned Les Roberts, the two deputies. And then Kevin then said, "Will you be interested to come to Joburg?" I said, "Of course I will."
We were in Grahamstown for a short period.
I was in Grahamstown for a very short
Oh,
short
I see.
period.
Okay.
Yes.
No, so that's why actually substantively you worked in Johannesburg. although
Substantively in
you
Johannesburg.
fired through Grahamstown.
Indeed,
Oh,
Chairperson.
no, I understand. Okay. And then you did work at the PCLU, which is the TRC cases unit.
Yes.
Okay. And how long was that?
It was for about less than a year. When you see, with the introduction of the NPA Act in 1998, the NPA, in terms of the Constitution, became a single prosecuting authority, and posts were then advertised for deputies. I applied, and I was appointed a deputy director of prosecutions in the Northwest. And then on the 1st of May 1999, I assumed my responsibility as a deputy director of prosecutions in the
Okay.
Northwest.
So you are at the national office for 1995 to 1998. No, sorry. You are at the DPP's office in Johannesburg up until 1998.
Yes.
But then you are only at the national office between November 1998 and May 1999.
Indeed.
Okay, I understand. And then in May 1999, you then go to Mabato.
Indeed, Council.
Okay. And when you were in Mabato, you were working as the deputy director.
Yes, I was working as a deputy director of public prosecutions.
Yes. All right. And then you were there until you went on retirement recently on the 4th of December 2024.
Yes, on the 4th of December, things took a turn. Yes, and I decided, I penned a letter informing the NPA that I had now reached the age of 660. I intend going on retirement.
I think you should explain those circumstances to the panel. I think they want to know
Yes.
what are the circumstances you say took a turn.
Chairperson, in February 2019, Advocate Shamila Batoyi was appointed as the National Director of Public Prosecutions. On a day, on a Friday, I was part to the office of the National Director of Public Prosecutions. PCLU is based in the National Director of Prosecutions office. And our office was on the same floor with that of the National Director. So as I walked to the photocopy, I would from time to time bump into the National Director. As I did on the day, in front of the lift, and Advocate Batoyi then asked me, "You are appointed for the Northwest. What are you doing here?" And then I then informed her that I am busy with work that was allocated to me by your predecessor. Her predecessor would have been Advocate Sean Abrahams, that I was specifically referring to. And then she thereupon said to me, no, you must go back to the Northwest. I was a bit taken aback by that stance. I indicated to Advocate Batoyi that I came to head office, to the office of the PCLU, as a result of having been requested to do so in writing. So I said, well, I have no problem with it, but may you please put it in writing. And then she said to me, now you can go to the Northwest. I will tell Johan. Johan then would be the Director of Public Prosecutions, Advocate Johan Smith, SC. This discussion, Chairperson, happens in the passage. And I would have expected a conversation that affects my work to have happened in a better, decent manner. I would have expected the National Director to call me to her office and to say why, in her view, I should go back to the Northwest. It did not happen. And then I went to my office, which is a few steps away from the foyer where we met. Chairperson, I barely sat down. It means I was just about to sit down when Danny Smith, the office manager in the office of the National Director, walked in. And when he walks in, he says to me, you know, he was rubbing his hands.
I beg your pardon, is that Advocate Smith?
No. Danny Smith is a corporate manager in the office of the National Director. He says, Advocate Mahema, please don't shoot the messenger. But you must vacate the office. And I say, vacate the office? Well, the direction from the National Director, Advocate Batoyi, is that you must go back to the Northwest. I said, but I just indicated to her that I needed it in writing. And he continued rubbing his hands and said, don't shoot the messenger, but you must vacate the office. I need to use it on Monday or the ensuing week. And I said, but Danny, I have files that I'm working on. And then Danny then said to me, well, those files can be put in the safe. So what they did was Danny Smith approved that some of the files that could fit into the safe could go into the safe, and those that can't fit in the safe, they gave me a bakkie, a van, that I loaded into the bakkie, and I drove home on that Friday in Joburg. And on Monday morning at 8 o'clock, I was in Advocate Johan Smith's office, to his surprise. And Advocate Johan Smith said,
Who is Advocate Johan Smith now?
He's a DPP in the Northwest.
So you were back in Mabato on
I'm
Monday?
back in Mabato now. And he was surprised. He was equally surprised. I said, well, I related the story to him. He said, no, you're most welcome here. We need additional hands. Your experience, no. Perfect. So that's how then I went back to the Northwest.
Yes. Now, at the time that you were essentially hounded out of the office, the disciplinary steps you are talking about in paragraph 10, had they been commenced, started?
They had not commenced yet.
Okay. Were you aware of any impending disciplinary steps?
I was completely unaware of any impending.
Yes. All right. And then take us through then to how, we now know how you were pushed out of the office by Advocate Batoi, according to you.
Yes.
Without warning, without notice.
Yes.
What we are still not aware of is what process led to the DC and what was the DC about?
Chairperson, what happened then was I went back to the Northwest and worked as a prosecutor normally. That means checking work of senior state advocates, checking work of advocates, and doing the work myself. Chairperson would remember that I'm one of the deputies who, unlike other deputies in other offices, don't sit in the office. I will do chamber work, but I will bring my own bit of doing court work self. So yes, I was doing the work of a deputy director of prosecutions and work of advocates in the DPP office, which included decision dockets, appeals, and doing circuit courts. Yes. Now, I think it was in May 2019, I got a call from the director of prosecutions then, Advocate Makari, then said to me, well, you will have to return the criminal cases that you're busy with. She wanted an audit of all the cases that I was doing, and she informs me that her instruction is that I should not do any court work anymore. And then...
When was this, the date you gave us?
It was in May 2019. This happened a day after I received a letter from Human Resources that was informing me of the commencement of a disciplinary hearing in 2019. But what surprised me was the angle that it took. I had part heads in the High Court, in the regional court, and I was simply told, you must make an audit of the cases, all the cases that you have, and then return them to the Director of Prosecutions, to Advocate Makari.
Advocate who?
Makari, Rachel Makari.
Oh, okay.
She was at the time the DPP.
She was at the time the DPP. Chairperson, she is in the province called Rachel Nengwavela. Yes. So, and then I returned all the files. I remember specifically that the next week I had made arrangements to go on circuit court. I was on circuit court with the Deputy Judge President. Judge Jaje, and at Mkhwase. That week, when I was on circuit court, Chairperson,
That Madam Justice...
Madam Justice Jaje,
Yes, okay.
I was then informed that I'm going to be served formally with papers commencing the disciplinary hearing.
So to just clarify something, because there might be unintentional confusion.
Yes.
In 2019, the DPP of Northwest was Mr. Smith, SC.
At the time of this incident happening,
Yes.
he had just left.
No, I understand that, but I just want the dates to be correct. In 2019, the DPP of Northwest was Mr. Johan Smith,
yes.
SC, correct?
Yes.
And when did he leave?
I do not have a specific date.
Yes, but your DC was not in 2019; it was in 2024.
Oh yes. No. What happened was it was commenced in 2019.
Yes.
The papers were served in 2019,
yes, correct.
And I was then asked to do these things, but the files and everything was retained at the time that Advocate Makari was the DPP.
Yes. All right.
Yes. And then what happened then was the result of this chairperson led to a prohibition to continue the court work that I was doing, and to continue doing any checking work. So what would happen is that I would literally walk into the office at 8 o'clock in the morning. I will sit in the office and read emails and read the newspaper, because I was prevented from doing any checking work. I was prevented from doing any work with a big salary that I was earning in the NPA.
Yes, but you mentioned that Advocate Rachel Nangobel told you that her instructions were that you should stop doing criminal work.
Indeed, Kansa.
What does that mean, her instructions? Who is instructing her?
The instruction came from the national director that I should not get involved in any. My continued involvement, the letter that I received, my continued involvement in criminal cases places the name of the NPA in disrepute.
Yes. But
Chairperson, this is an institution that I worked tirelessly for 31 years. Now, all of a sudden, because of a decision that has been taken in the line and scope of my work, I am now in a position where my continued work will place the NPA's name in disrepute.
Yes. When you say the national director, let's call her by name.
Advocate Shamila Batoi is the one who instructed Advocate Makari to remove me from any active work within the NPA. The result, Chairperson, was that...
Did you say that this message was conveyed to you whilst you were at the circuit court?
The reason why I mentioned that week of the circuit court, when I was told that head office wants to find out where I was so that they can come and save me with the documents. I was at circuit court in Mkhwasi. And then this fear was there that, what would then happen with the part head that I'm doing? And then during that week, in the morning in chambers, I indicated to Madam Justice Judge that there is this pending thing that might happen. And if it happens, I don't know whether it will affect my ability to continue prosecution in the matter that I was busy with. But then what happened was we did the circuit court until the Friday. And the letter of suspension did not arrive. So it arrived later. So the result was that in 2019, after I was told, you're not getting involved in any work, I then became redundant. Coming to the office, reading the newspaper, and doing absolutely nothing. This is a man who is used to running around, reading dockets, working under pressure, and all of a sudden, it's a complete dry land. I have nothing that I'm doing in my office. Chairperson, it went to an extent where I would, junior staff in the office would not know what is happening. So they would come to me and say, Advocate Maima, I have a challenge with this. and I would give them advice as to how to deal with it and say, go to the library, look at this and this. And at some instances when I have challenge, because pressure in the DPP office is enormous. So I say, no, bring it, I will do it. So I would do work and not be able to sign that I have done that work and give it to that junior advocate or that senior advocate to present it as his own. I would not be able to sign indictments. You know what happens in the DPP office? A file comes to you, you issue queries on the matter docket. When it comes back, the admin section will bring it to you. Then they would bring it to me, not knowing that I am not in a position to decide that docket. And then when they bring it to me, then I will take it back and say, I'm not in a position to handle it. So this redundancy happened from 2019. The disciplinary hearing was pending. It wasn't commencing. You know, ultimately when I received the papers, Chairperson, I discovered that it is the decision that I took in the Johan Boysen matter that led to all of this that was happening.
Just tell me, on the point of the DC not commencing, I mean, most of us have done labor law before.
Yes.
When there is a DC, a prosecutor is appointed, a pro forma prosecutor is appointed.
Indeed, Chairperson.
Who must sign the charges.
Yes.
And then bring witnesses and prosecute.
Yes.
Was a prosecutor appointed in your case? Or an initiator? Yes, I'm corrected.
Yes, an initiator was appointed.
Who was the initiator?
He is sitting here. It's Advocate Harley, I see.
I see. Was a chairperson appointed?
The chairperson wasn't appointed yet. The charges remain pending, and we complained. We took the NPA to the CCMA, and there was the postponement. There was a judgment ultimately, but the effect thereof was that I remained redundant in the office, doing nothing.
So an initiator is appointed, but no chairperson.
Yes.
All right.
And then on the 4th of December 2024, I decided, no, I cannot be treated in this manner by an institution that I've given my entire life, 31 years of my life. On the 4th of December, I then penned my letter informing the employer that I'm intending taking retirement as I've reached the age of 60. I was not the only one, but Gudmu Singh, who was also in the same position, did the same thing. In fact, he did it a bit earlier than me.
Yes, well, we will see Advocate Masing's name does feature.
Yes.
But maybe to complete that part, now that you've introduced him, when you say he was in the same position, what do you mean?
Counsel, if I may interpose, and I apologize. You said after you went to circuit court, the letter of suspension was served on you a week later.
Yes.
What did the suspension entail? Were you supposed to sit at home, or were you supposed to come, report at work and do nothing? Maybe clarify us on that.
The latter, Chairperson. Come to the office, sit in the office and do absolutely nothing.
Let me understand. You are suspended?
Yes.
But you come to the office and do nothing?
I'm sorry, Chairperson. Suspended with full pay.
Yes.
You come to the office, and there's a concerted effort to ensure that I arrive on time. Arrive at 8 o'clock. Because when I arrive, the securities will say, Mr. Maima, please, because sometimes you walk in and you're rushing, you don't sign the register. Say, no, please, you must sign. I say, what do you mean I must sign? I have something that I'm rushing for. No, please, it's important, you must sign. We have been asked to direct you to sign, then I would sign the register relating to the time at which you come to the office.
Thank you.
But then do absolutely nothing. Chairperson, there is nothing that frustrated me during that time, like coming to the office and wanting to do work and not being able to do work. The work that I've done for that period of years was very frustrating to me. But I couldn't do anything about it.
Look, Mr. Maema, what might help?
Through you, Chair.
Oh, sorry.
Thank you. Advocate Maema, you say you were suspended, but expected to report at work at normal working hours.
Yes, Chairperson.
And is that spelled out in your notice of suspension?
It was not in so many words, but I was told I'm suspended with full pay. What was communicated to me by Advocate Makari at the time was, you are not allowed to touch any work in the office. So it wasn't specifically mentioned in the letter of suspension. The letter of suspension indicated that here are the charges that you're going to be facing, and you are suspended with full pay. A disciplinary hearing will commence. These are the charges.
And you have that letter of suspension?
Yes, I do.
Right, thank you.
Yes, Madam Ramachakha is on this point, because I was going to say what might be helpful is for you to bring us that letter at some point and we'll share it with the panel.
Indeed.
And the instruction for you to come to the office on time was conveyed verbally. Is that your evidence?
My evidence is that the securities in the office indicated that I am compelled to indicate the time of arrival and to indicate the time of leaving the office.
Yes.
But when I had when I was told by Advocate Makari about the suspension, she did not in any way mention signing the register, attendance register.
All right. You mentioned also that the initiator was Advocate Hali SC. How did you know that?
We had various meetings with Advocate Hali.
Oh, I see.
Yes.
Meetings to do what?
We were told to appear on a specific date, and we came to the CCMA office in Sandton here, and Advocate Hali then had a meeting with the counsel who was representing us, Advocate Matibedi, SC. Yes, and there were some discussions, and I think there was a chairperson appointed, because then the hearing was postponed to a further date. Advocate Hali would remember. Those are the sad parts that I don't really want. My brain does not have capacity to keep that negativity. You think about it and you push it away because you don't want it to drag you down.
Yes, all right. So you think your memory could be failing you that the chairperson could have been appointed or was definitely appointed?
I think the chairperson was appointed because we went to the date. We went to the hearing, all of us, Advocate Musing, Advocate Matenjwa, Advocate Marshal Mukhatla. Yeah. And the matter was postponed to a further date. This matter was postponed and postponed and postponed. That's why I said because of the frustration, we then went to the CCMA. We didn't get a favorable judgment, but the effect thereof was wearing you down. I decided on the 4th of December, I have had enough. So I said, no, I am going on retirement.
You said you discovered at a certain stage that all of this was caused by the role you played in the prosecution of the Cato Manor accused.
The charges were spelling it out clearly that it is because of the charges in the Cato Manor
Yes.
that I was or that I suffered the fate that I was facing. When I look at the terms of reference are almost the same as what I faced.
Which terms of reference?
The terms of reference of this commission.
Of Advocate Chauke.
Advocate Chauke's terms of reference. It refers to paragraph 3.1.1. 3.1.1 talks about the institution of the racketeering charges against Major General Boysen. But 3.1.1 says Advocate Chauke supported a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. 3.1.2, Advocate Chauke recommended to Advocate Jiba, the acting NDPP, the application for issuing racketeering authorization, whereas there was no evidence justifying the institution of prosecution. So it is a pattern of just accusing us of instituting prosecutions where there is no evidence. It's the same pattern of what happened to me is same as what is contained in the terms of reference relating to Advocate Chauke.
Yes. All right.
Madam Chair,
we will come to.
Sorry to interject. May I ask, Madam Chair, it's hot that we take off our jackets. It is raining on our backs. We are
Well,
sweating.
the air conditioner was switched on and then it seems to have been switched off. I apologize. I know you asked me to make the request. I totally forgot.
Yes, Advocate Maema, we're all battling with the heat and the coldness. You'd understand why some of us are in this state. Are you feeling cold where you are? If you were to switch on the echo,
It would not affect me at all. I will welcome it, Chairperson. The seat is fairly hot.
yes, I will request our assistants to help us. The lady Colin, if you can assist with the remote and make sure that air conditioning is well functioning over there.
Unfortunately,
But
Madam
that does
Chair,
not detract from the fact that I'm talking to you now.
apologies.
That does not detract from the fact that you can take off your jacket if you wish.
The reason I was saying is because that one only assisted Chauke team.
You can take off your jacket.
Thank you, Madam Chair.
Madam Chair, I'm in your hands when I should proceed.
Advocate Maema, when you feel cold, you can just regulate the air conditioning with that gadget.
Thank
Or
you,
you can
Chair.
even take off your jacket if you are inclined to do so. I know you're smiling. I know you will not do it.
I will not.
Knowing you from past experience, I know you won't take off your jacket.
Our court etiquette has taught me to do things in a particular way. That's why I am not comfortable
I know you, Mr. Maema.
to take oath sitting down, really.
Thank you. You may proceed, Advocate Ngcukaitobi.
Thank you, Madam Chair. All right, so we are now at the point where you've, according to you, have had enough of the unending disciplinary inquiry, and you also know the substance of it is that you are being charged because of your role in the racketeering and the predicate charges on Cato Manor. But you've had enough, you want to go. And you wrote a letter which is called the Termination of Service Letter dated 4 December 2024. We also don't have that copy. Perhaps when you bring the suspension letter, you can also bring that one.
Termination of service letter.
Yes.
Because what happens, Chairperson, is you type it on your own computer, and then you print it, you sign, you give it to HR. But I should have the version on my laptop.
Now, was there a separate charge sheet which explained what the allegations were?
Yes, there was.
All right, so perhaps if you could also provide us with that one. So far, just out of paragraph 10 alone, we have 3 documents we've asked you for. It's your suspension letter and your notice of disciplinary charges and your resignation letter. Okay. And you say that your last date of employment was 31 January 2025.
Indeed, Chairperson.
Yes. Now, what are you doing right now? Well, you've had a year and a month since you left.
Yeah, what happened then is I then applied to do pupillage. I was admitted to do pupillage in Polokwane, the Limpopo Society of State Advocates. That is where I met Advocate Mutlamunyani, who was then offering me legal writing. Yes, so I started there on the 1st of Feb until the end of August when you wrote exams. And I think the results came in August, September. I think the beginning of October the results came. But it was a long wait.
Yes.
You know, waiting for the results of that exam is also not a nice thing.
Yes. And are you practicing now as an advocate?
Chairperson, I am commencing to open my office as an advocate. At the moment, seeking chambers from which to practice. But the sweet and short answer is yes, I am practicing as a.
Where, in Limpopo or in the Northwest?
Chairperson, because my house is in Gauteng, I'm looking for chambers in Gauteng.
All right. Thank you very much.
Yes.
Now, okay, we've covered now paragraph 10 because there's quite a lot of information that's condensed in one paragraph.
Yes.
And then when we look at paragraph 11, we also cover your experience that you've had as the DPP on an acting basis. Can you just take us through that?
Indeed, Chairperson, I acted as a Director of Prosecutions on several occasions. This includes the times when Advocate Smith, SC, was sick. Advocate Smith is elderly. He's been very sickly since 2000. In fact, the saying I acted for 7 months is an understatement. I think 7 months was a continuous period when he was admitted in hospital. But because of his age and because of his frailty, I was acting in his states, fairly regular. And then in 2010.
Before that, after completing your pupillage, did you sign the Red Book at the Limpopo Bar or any other bar?
I signed at the Limpopo Bar.
You see, you're currently the Limpopo Bar member?
Yes.
Thank you.
And I also informed them as practice requires that I will be testifying as a witness. I do from time to time when I'm called by the DPP office to testify in respect of cases that I do in organized crime. So when I was asked to consider coming here, I did inform them.
Yes, thank you. proceed, sir.
Thank you, Madam Chair. Okay, so we were still covering paragraph 11, which is really your experience as DPP, although your substantive post was deputy.
Yes.
But you also had experience as DPP.
Yes, I acted when my own DPP, Johan Smith, was not well. And when the then DPP of South Gauteng was Advocate Karen de Beer SC, she is mentioned in paragraph, the end of paragraph 11.
Yes.
She was also on sick towards the end of her career. And Advocate Mche, who was then the acting NDPP, asked me to go and act in Joburg, which acting period was 1 December 2009 to 31 May 2010.
Yes, you also had experience as the acting head of the PCLU, that's the TRC cases unit.
Yes, I would do that when Advocate Pretorius was out of the country, or when he was ill, or when he was unavailable for any other reason. Then I would be given an acting appointment.
Yes. So, I mean, it does appear that you have significant experience at high level inside the NPA. It's not just the time, but it's also the type of experience you've gained.
And the kind of responsibility that the NPA is prepared to bestow upon you. It went to an extent where I said, no, I will not accept any other acting appointment. You appointed me as a deputy, I'm fine as a deputy. I will execute my duties and responsibility as a deputy.
Yes. Right. Now, your functions as the deputy director are set out at paragraph 13. Can you briefly deal with those?
Chairperson, as Deputy Director of Prosecutions in the office, I was entrusted with special prosecutions, I was entrusted with governance, and I was entrusted with the organized crime. But predominantly my portfolio was organized crime. And organized crime then leads you to dealing with racketeering cases, serious violent cases. Yes.
Well, I mean, South Africa's primary legislation on organized crime is the Prevention of Organized Crime Act, and racketeering is a feature of that act. So
Indeed,
if you are a specialist in organized crime, that would be your area of specialization.
Indeed.
Yes. And also, not only were you in charge of organized crime, I mean, you had specific knowledge and expertise in racketeering.
Chairperson, I have dealt with a number of cases.
Yes.
Both as a prosecutor in court, and as well as the cases that I would push through or prepare and send to the National Director for racketeering authorizations to be issued.
Yes. And that is what is in the last sentence of paragraph 13, is your experience specifically in racketeering.
Indeed, Councillor, I indicate that I've prosecuted 5 racketeering prosecutions in person.
Yes.
Whilst I was in charge of about 7 racketeering prosecutions, where I would then supervise and guide and take the process through to the issuing of racketeering authorizations. The process of issuing of racketeering authorizations is the prosecutor must then prepare a prosecution memo where you summarize the case, where you summarize what is involved in the matter, where you pinpoint the enterprise, the pattern of racketeering authority, pattern of racketeering activity, and then in a memo, depending on whether you do the prosecution in the regional court, in which case then you prepare a charge sheet. If it's in the high court, then you'll prepare an indictment together with the requisite racketeering authorizations for consideration by the Office of the National Director.
Yes. No, I understand.
Let me just verify something you said earlier with regard to the disciplinary hearing. And when you appeared before the CCMA, You mentioned the names of Advocate Musing, Mokhatla, and Matenjo. Were they also subjected to disciplinary proceedings and charged?
Yes, Chairperson, we were charged in the same matter. In fact, what happened, disciplinary hearing in terms of the labor legislation, for some of us who've read labor law, is supposed to happen in the office where you're working. But the NPA was then, despite my being based in the Northwest, said, well, because it is involving Advocate Musing, who is based in the DPP Pretoria, Advocate Mokhatla, who's based in the DPP Pretoria, but head of a serious office of the OCO, what is it? Serious economic cases. Advocate Matenjo.
We can refer to it as OCO. I think we know.
OCO, yes. And Advocate Matenjo, who's a deputy in the office of the DPP in South Gauteng. So, well, including myself, we were all officials of the NPA who were pursued disciplinary by Advocate Hali SC.
No, Advocate Hali was just an initiator. You were being pursued, if by any person, by Advocate Batoi.
Indeed.
Yes. Okay. I think the point I was trying to get to in paragraph 13 is to expatiate your knowledge and expertise in racketeering, which we've dealt with now, I think, unless you want to add anything on your experience and knowledge of racketeering.
Now I have, except to say, Chairperson, when because of my experience in racketeering cases, and because of having dealt with the cases myself, this now leads me to paragraph 15, where I say, I think in my view...
let's start with 14. There is a case...
14. In section 2 of POCA, or in the definition section of POCA, and an individual can be an enterprise. A group of individuals associated, in fact, can be an enterprise. Even a formal structure with hierarchy can be an enterprise. So all you do is look at the legislation, look at the facts that you have. Do they accord with the definition of an enterprise? And do you have sufficient evidence to prove an enterprise and all the elements, pattern of racketeering activity, there being more than one offense listed in Schedule 1. If all the requirements outlined in the legislations are there, then, you commence a racketeering prosecution.
Yes. Thank you. And then in paragraph 15, that's where you wanted to go to, that you think the reason you were recommended to be involved as a leader of the prosecution team on Cato Manor was because of your experience in racketeering.
At the time, yes. At the time when it happened, I thought, oh, well, it could be because of this. Because every time when you go to a conference, they'll say, Mahema got this conviction of an individual as an enterprise. Yes. So I thought it is because of that involvement in the Ngongoma Ntleleni matter, that the acting NDPP advocate Jiba, when it was brought to your attention that there is something in KZN that might mirror what is in racketeering offenses, then she thought of Mahema, who has done racketeering cases, and also thought about Matenjwa. At the time, in 2010, Advocate Matenjwa had dealt with the Jub matter. It wasn't a racketeering matter per se, but it was a matter that caused a lot of, what do you call it? A lot of unhappiness in Soweto. It happened at the time when I was acting in Johannesburg. So I actually allocated the Jub matter to Advocate Matenjo and Advocate Kanyile, but Advocate Matenjo dealt with that prosecution and dealt with it successfully. So when incidents in KZN were happening, which would mirror something that may be in that line, I thought that was the reason for the recommendation that I be part of the team. But then, having spoken to General Mabula, who was the lead investigator of the DPCI, the Director of Priority Crimes Litigation Unit, then I gathered that when he approached Advocate Jiba for a prosecutor-guided investigation in respect of this incident, Advocate Jiba asked him, is there a prosecutor that you know that would recommend? General Mabula is in the Northwest, I'm in the Northwest. I was his obvious choice. He said, I work with Mahema in organized crime. Yes. And because of Advocate Matenjo's involvement in Jub, in my view, then we were the two that were designated to assist the DPCI team as well as the IPAD team in KZN with what appeared to be offenses in KZN.
Yes, thank you.
Correct me if I'm wrong, was the further reason also not the fact that there had also been a case involving someone in Rustenburg who then had to be prosecuted in KZN with all others? The Rustenburg case.
Now, the Rustenburg case was in my view not a consideration. I thought it was my experience in racketeering matters, and Chairperson, there was a prosecution that I dealt with at the so-called Skirlek prosecution. The Skirlek prosecution was a racist attack in Swartregens. So it was one of the prosecutions that was in the media a lot. So I dealt with that matter. And,
you're not going to my turf.
Oh yes, I have missed the question. My apologies.
No, the Skirlek matter is in my turf.
Oh yes.
Yes, but I do understand those reasons why you were then recommended to go to KZN and lead the team. I thought that perhaps the Rustenburg matter was also a consideration. I do understand your answer.
Yes.
Looking for the actual case.
Yes.
Yes, I was just checking, Madam Chair, that centralization case. I'm just looking at my notes now. But I suppose that came after you were approached. That's your point.
Remember the...
Yes, I think it will come later.
We will deal with it,
we
yes.
should not divert at this
We will deal
stage.
with it.
Advocate Mahema, I think just to save time, let counsel take you there at a later stage.
Thank you. Thank you, Chair.
Right, thank you. So, paragraph 16, you already showed us your familiarity with the terms of reference, so I won't get into that because you mentioned that voluntarily when I was asking you about something else.
Oh yes, about the...
I was asking you about your own DC, and then you said it's actually mirrored in this DC, and then you read out the terms of reference.
Indeed,
Yes,
indeed.
So we can skip paragraph 16 there. And then in paragraph...
Is it, I'm now reminded of the tea time.
Yes.
Flies.
Yes.
We have gone past the tea time. I'm reminded it is now tea break time, so Advocate Ngcukaitobi, do you want to pause now or do you want to pursue with that question?
No, Madam
Or
Chair.
you'll park it here until we reconvene?
Yes, I'd rather park it here. Thank you.
Yes, thank you. Advocate Mayama, we've agreed with council that we'll take our lunch, beg your pardon, the tea time at 15:15, and then we will adjourn for 30 minutes. We will reconvene at 10 to
10 to 12.
10 to, yes, at 10 to 12. For you to proceed. Remember, you are still under oath as we adjourn. Thank you, Council. We'll adjourn for tea for 30 minutes.
Able.
when because of my experience in racketeering cases and because of having dealt with the cases myself, this now leads me to paragraph 15 where I say, I think in my view...
let's start with 14.
Should we start with 14? In section 2 of POCA, or in the definition section of POCA, and an individual
Good day, everyone. Advocate Ngcukaitobi, Mr. Malema, Mr. Maema, not Mr. Malema. Mr. Maema, remember you are still under oath. You may proceed, Counsel.
I do, Chairperson. Thank you.
Thank you. Mr. Maema, we've skipped paragraph 16, and we are at paragraph 17 of your statement. And where you say that you were responsible for coordinating the prosecution team, preparing the prosecution memoranda and draft indictments, and engaging with the processes required for racketeering authorization under POCA, and you have first-hand knowledge of the evidentiary material available at the time, the decision-making processes, and the role played by Advocate Chauke. Could you just explain that?
Indeed, Chairperson. I start with saying I am well placed to deal with the allegations against Advocate Chauke. That notion of no evidence. Because as a lead prosecutor, I was confronted with that evidence. I went through that evidence. Well, obviously, as a lead prosecutor in the state case against Major General Boysens and member of the Cato Manor unit, I took the responsibility to coordinate the activities of the prosecuting team, which includes preparing the prosecution memoranda. I don't like the term draft indictment, the indictment. And engaging the process required for racketeering authorizations under POCA. I confirm that I have first-hand knowledge of the evidential material that was available and the decision-making process within the NPA. And Advocate Chauke, who was coordinating in the beginning phases of the investigation, I'm convinced with the role that he played. And I will be able to deal with the issues that are raised in the terms of reference.
Thank you very much. We can skip paragraph 18, 19, 20, 21, 22, 23, 24, because they are just a guide to the reader of the statement about what is to happen in the statement.
Indeed, Counsel.
And go to paragraph 25, where you say upfront, Advocate Chauke did not fabricate the case or support the prosecution in the absence of evidence. Can you just, in a snapshot, explain what you mean there?
Chairperson, I refer in the first sentence of paragraph 25 to proper institutional and evidential context. And I say it is clear Advocate Chauke did not fabricate any case to support the prosecution in the absence of evidence. And I am emphatic that his involvement was a limited role, that of coordinating the role within the chain of command within the NPA. The decision to prosecute was grounded on extensive prima facie evidence, which is contained in the dockets and taken through a collective prosecutorial process engaged with by the prosecution team, which included the prosecutors, members of the DPCI, as well as members of the IPED. When I talk about proper institutional context, Chairperson, as a deputy within the NPA, I communicate through my DPP at all times when I communicate to the NPA. And when I communicate to the NPA, it means when you communicate to the national director, the upper structure of the NPA. I do not have a direct line to Advocate Chamila Batoy or to Advocate Ramaide as he then was, a deputy national director. So in my capacity as a deputy director, I communicate through my DPP. Now, we were based in the DPP office in South Gauteng. That's the office where we were working from. The majority of the staff was in that office. So any communication that came from the prosecution team, together with the investigation team, had to be channeled through a DPP. And the most appropriate DPP to channel it through is the DPP who's close by to us, who's offering us a boardroom from which we could work, which was Advocate Chauke. But I must emphasize that the decisions that were taken is the decisions of the prosecutors. All that Advocate Chauke did was a conduit to convey what we had decided to the upper echelon of the NPA. At no stage did he sit in any deliberations, or at no stage did he question any of our decisions. What he did was, if I communicate to the national director, I will do a prosecution memo or do a covering letter in the name of a DPP. And the nearest DPP was Advocate Chauke, who had offered us a boardroom from his office from where we were working. So he was just a conduit to convey any message that you wanted conveyed to the upper echelon of the NPA, to the national director.
Yes. Look, we will have to come back to this on the specific decisions, but
yes.
I think at the moment you are probably at the right place to just explain the difference in role between the leader of the prosecution team, of which you were,
yes,
and the coordinator of the prosecution, of which Advocate Chauke was.
All right. Now, myself as a leader, I was coordinating the functions and activities of the prosecution team and our relations with the team led by the DPCI, as well as the team led by the DPCI. Yes. And Advocate Chauke's role was strictly to update him so that he can update the national director. The command structure of the NPA, a deputy, prosecutors, chief prosecutors, everybody communicate through the DPP. So all he did was just, a conduit through which our decisions or any hurdles or any challenges that we had were channeled through him.
Yes. And in this inquiry, there has been haggling, certainly introduced by the evidence leaders, about this concept, prosecutorial decision.
Yes.
On the one hand, a prosecutorial decision is a decision to institute or retract a prosecution.
Indeed.
But there is a range of other decisions in between.
There's a range of other incidental decisions that one takes in the process. Yes.
And who was taking those in this case?
The prosecution team will take all the decisions.
I see. So
yes.
You were the person.
That is myself and the list of advocates that are mentioned on page 16 of the affidavit, paragraph 57.
Yes. Yes, we'll come back to those, but the point is this: the decisions about evaluation of evidence, identification of witnesses, whether a charge is good or bad, all of the, I would say, classical prosecutorial decisions were taken by yourselves.
Those decisions were taken by ourselves as a prosecution team.
Yes.
Yes.
And where Advocate Chauke signed documents, they were actually drafted by you, but because you had no line of sight to the...
Absolutely. I was the one drafting the documents, and he was my mouthpiece, so to say.
Yes, thank you very much. All right, we'll come back then.
And I assume, Counsel, that we are speaking in terms of the Cato Manor cases.
Indeed, Chairperson.
Nothing outside that, at least for now.
100%, Chairperson.
If I may, Advocate Ngcukaitobi, do you know why Advocate Chauke was made to depose to an affidavit before the Zondo Commission of Inquiry?
Chairperson, the Zondo Commission was investigating what was referred to as state capture, the capture of institutions of the state. And Advocate Chauke, just like myself, just like Advocate Musing, like Advocate Mukatla and Matenjo, we all deposed to affidavits outlining our roles in Cato Manor, and basically showing that we have not been captured by anyone. We were merely doing our work as expected of us.
As I read Advocate Chauke's affidavit before the Zondo Commission, it seems that certain allegations were made against him by Major General Boysons and Advocate Mlojo, if my recollection is correct.
Advocate Mlojo, who was the acting DPP of KZN. And I'm asking that...
You may not be aware of that, but
yes.
I asked the point with a view to ascertain, I beg your pardon, whether in your understanding of the allegations leveled against him, if you do, it seems that the allegations were that he made decisions which were motivated by ulterior motives and were biased.
Those are, in a nutshell, the allegations, yes.
Yes. Now, I ask this question because you've just been talking about prosecutorial decision making.
Indeed, Chairperson.
Now, if you say that decisions that were made in relation to the Cato Manor matter were all made by the prosecutorial team, including yourself as the leader of that team, that seemed to exonerate Advocate Chauke insofar as the prosecutorial decisions, the impugned prosecutorial decisions are concerned. Am I correct?
You are 100% correct, Chairperson. Those decisions were taken by me and the prosecution team to the exclusion of Advocate Chauke. Those decisions are ascribed to us. They cannot be ascribed to anyone other than the decision maker, who is us, the prosecution team.
Yes.
Yes. Thank you, Madam Chair. There is a legal section from paragraph 28 which tracks from the Constitution to the Act up until paragraph 32. That the commissioners are familiar with the law, but I think in one sentence, what is the importance of those sections for your statement?
Those sections outline the single prosecution service which has been established in terms of the section 179(2), I think, of the Constitution.
Yes.
Yes. Section...
Well, you actually deal with that concept at paragraph 30.
Yes. It was important in terms of section 179(1) for a single prosecution service to be established in 1998, because prior thereto we had attorney generals, and the attorney general in Pretoria could take a decision, was independent, and he could take decisions relating to prosecution of matters in the Pretoria area. The DPP in South Gauteng, in the Northwest, in the Free State, in the Eastern Cape, they could all take their own decisions, and their decisions could not be questioned by any other person. So when Section 179 introduced national legislation in terms of which a single prosecution authority was established, the national director was established. And that national director could then, in terms of Section 179.5, review decisions of DPPs. So my understanding, Chairperson, is that original prosecution powers vests in the DPPs and the prosecutors in the regions. The national director has review powers in terms of Section 1795, and those review powers are exercised where there is a representation from the accused person, from anyone affected by the decision consent. But there must be a complaint to the national director for the national director to exercise the review powers that are in Section 179.5. But the national director can, of course, a matter of national importance or a matter that is causing uproar in the community, ask the concerned DPP, what is happening in this matter? And can you give me a report in respect of this matter? But my understanding of the NPA Act is that original prosecution powers vests in the DPPs and the prosecutors in the DPP office.
Yes. Well, there's a second element to this concept of single, which is there is now one boss who can instruct Advocate Mayema to leave the Northwest and go to KZN.
Of course.
You can also instruct Advocate Chauke to leave Gauteng and to go to KZN.
Yes, but national legislation,
yes,
the NPA Act regulates how that should happen.
Yes.
Like Section 24A of the NPA Act,
yes,
the 1998 Act, says a deputy director of prosecutions can exercise the powers that he has within the area where he has been appointed in terms of Section 24A.
Yes.
But in terms of Section 24B, he can exercise powers, prosecution powers, in relation to those instances where he has been authorized thereto in writing by the National Director of Prosecutions. So, Mayema being myself appointed in the Northwest, I exercise prosecution authority in the Northwest. But should the National Director deem it appropriate in terms of Section 24B of the National Prosecuting Authority Act 1998, the National Director can give me a delegation in writing and say, Mayema, who has been appointed in the Northwest, I delegate you to go to KZN and to look at this incident. And those incidents must be mentioned in the delegation. So it cannot be a wide go and do whatever that go. It must be with specific reference to like in a case of Cato Manor, the incident involving the killing of people, the killing of people within the taxi violence situation that was happening in KZN.
Yes. And specifically in your case, we've got your delegation at page 1A, 151. Just to confirm the point you've just been making. 151, yes.
Chairperson, it is GSM 4.
Yes.
It is a delegation issued by Advocate Nomkobo Chiba, who was then the acting National Director of Public Prosecutions at the time, who in terms of Section 20, Read 21, 22, and 24 of the National Prosecuting Act, authorized Sello Gladstone Maema, who's myself, to exercise powers set out in Section 21. So in Section 21, it is prosecution powers. In the lower court and in the high courts, within the area of jurisdiction of KwaZulu-Natal division. Now it mentions, if it didn't have this section, I would have queried it. In all offenses committed by members of the South African Police Service in the province of KwaZulu-Natal, and to act on behalf of the state in any appeal, any review, or other applications arising from such criminal proceedings within the province of KwaZulu-Natal, subject to the prosecution policy of the NPA and any direction of the National Director.
Yes.
So here, in addition to the power that I have in terms of Section 24A, in terms of Section 21, I'm authorized by the acting National Director to go to KZN and look at what is happening in relation to all offenses committed by members of the South African Police in the province of KwaZulu-Natal. So it is specific. I can't go there and deal with offenses relating to any other things except those ones specified in the delegation.
Yes, I mean, is that why then you say you took all of the decisions and you asked Advocate Chauke to be your conveyor belt?
To convey them.
Yes.
So Advocate Matenjwa, who was in the same capacity as myself as a Deputy Director of Public Prosecutions, also had a delegation worded similarly to this one.
Yes, well, we've got it here at the following page.
Oh, yes.
1A 152.
Yes. Chairperson,
If I may, before you proceed, the delegation, GSM 4, is in terms of Section 25 of the NPA Act. Am I correct?
you are
Among other provisions.
amongst other provisions.
provisions.
You are correct, Chairperson.
So you'd have to read them together.
You have to read them together, yes. Yes.
And of course, 20 sub 5 does not specify whether the person delegated with the powers would then be acting outside of his or her jurisdiction.
Outside the area of
Yes.
jurisdiction to which he has been appointed.
Yes,
Yes,
yes.
Chairperson, you're very right.
Thank you, Madam Chair. All right, we've covered then the import of 30, 31, and 32. And then there is also the code of conduct that you've referred to at 33, 34, and 35. And to some extent 36. Do you want to just cover that?
Well,
And that has got to do now with the regulation of the decision making by prosecutors.
of course, yes. Now, that exercise of a prosecution discretion in terms of Section 32, 1A, I'm at paragraph 31, will have to be exercised impartially. Prosecutors have to carry out and perform their duties and functions in good faith, but importantly, without favor, fear, or prejudice, and most importantly, subject to the Constitution and the law. So a prosecutor exercises his discretion in terms of the law. So what it means in terms of the law, it means I can't do it in a vacuum. I must have a docket that has allegations that are under oath, which allegations I am of the view that amount to a prima facie case before I can prosecute, before I can take a decision to prosecute.
Let us assume, and I take into consideration your very clear answer that Advocate Chauke did not make any prosecutorial decision. But evidence has been tendered here that he made certain prosecutorial decisions. Let us assume that they are correct, or Advocate Batoy is correct, that he did make certain prosecutorial decisions. Shouldn't we then be taken to the provisions of the Constitution, read with the Act, to identify in what respect precisely did he deviate from the provisions of the Constitution and the law?
Indeed, Chairperson, I think I submit you are very correct, Chairperson. If any allegation is made that he performed any function contrary to the law, then that section has to be referred to. But insofar as the Cato Manor matter was concerned, I was the lead prosecutor. I and my team took all the decisions relating to the Cato Manor. And all we did was, because of the protocol in the NPA, of not being able to communicate directly to the national director, he exercised a coordinating role of ensuring that whatever that we decide is communicated correctly to the national director. And this would happen by means of briefings that we do to him and reports that we will write to him. So until when Mr. Ngasana directed that he should not be party, he should not partake because he is appointed only in South Gauteng. Before then, being prosecutors who are based, or being a team that was functioning from his office, we saw no other person to communicate the decisions that we have taken, to communicate prosecution decisions that we have taken to the national director. We used the director of prosecutions, who was close by to us.
Thank you, Advocate Nkcukaitobi.
Thank you. You know, what I hadn't noticed until recently was that your delegation also included litigation. So if there is a case that comes to challenge the decisions, you actually had the mandate to defend it.
Indeed,
Yes.
Chairperson, we did. It's specific in the delegation that if there is any review or any appeal, we are mandated to deal with it.
And you know now, Mr. Chauke is now charged, among others, for supporting the opposition, the institution, firstly the opposition to the review and the institution of the appeal.
Which is very absurd when the NPA knows who made those decisions. It's no secret. The prosecution team, Mahema and his prosecution team made those decisions. And when the government judgment came out...
The judge governed judgment.
My apologies, Counsel. Judge.
Yes, thank you.
Yes.
Thank you, Counsel. When the judge governed judgment came out, we had a meeting. We had a briefing session with the counsel who dealt with the matter, Advocate Lawrence Howdes, SC. And we registered our dissatisfaction with him, and we informed Advocate Chauke, our coordinator, who was conveying all our decisions to the national director. We informed him that we formed a view that we should appeal this decision because we don't agree with it.
Not only appealing, but opposing the review application also, I suppose?
Initially, Chairperson, we considered appealing it. But if you go through the decision of Judge Govan, you will see that
you're not answering the right question.
Okay.
The judge is asking the decisions that the prosecution team took did not only include appealing, but also included opposing initially.
Of course, yes.
Ab initio, opposing the review.
Yes,
That's
you
what
are
the-
very right, yes.
But that's what the judge was asking you, not me.
Yes,
Just
thank you,
answer that
Counsel.
question.
Thank you, Counsel. Thank you.
Thank you, Chairperson. We also had the authority to oppose any application that would have been launched in challenging any decisions that we had taken.
But as a fact, who took the decision to oppose the application by Mr. Boysen?
The prosecution team took that decision. Myself and the prosecution team took that decision to oppose it.
Yes.
And at no stage was Advocate Chauke part of the decision. What we did was we communicated our decision to him to communicate it to the National Director.
Yes. Thank you, Madam Chair. We've finished
And
the...
that what is supposed to be obvious, the respondents. Who were the respondents in that matter, by the way?
The respondent was the acting National Director, because what happened was Advocate Lawrence SC, who was Advocate Lawrence Howdes SC, who was appointed to deal with the matter, then dealt with an affidavit in the name of the acting National Director, Advocate Jiba. And as a prosecution team, we were kept in the dark. We did not see that affidavit until it was filed.
The appeal in the SCA, the NPA was the appellant, correct?
Correct,
No.
Chairperson.
And we are told that Advocate Chauke deposed to an affidavit on behalf of Advocate Jiba. Insofar as that appeal is concerned, I'm not sure whether I'm mixing the facts. This is subject to correction. But even so, does the mere fact of deposing to an affidavit or drafting an affidavit on behalf of the head of the NPA in and of itself mean that he was instituting an appeal himself, Advocate Chauke?
No, Chairperson, not at all. Because it was our view ab initio that that decision of Govan J should be appealed against. And Chairperson, maybe if I should mention that when Advocate Ngasana was appointed later, and the appeal was pending, he gave us instructions to not to appeal that decision. Says, if you look at paragraph 39 of Honorable Govan J. Judgment, it says, if there is sufficient evidence emerges, or if the state procures sufficient evidence, nothing prevents them from approaching the National Director afresh to procure fresh racketeering authorizations. And that was a decision that we took. Instead of appealing, when we were told that not in my name will you appeal, we said, well, the judgment allows us to go back to the drawing board and to secure evidence justifying the issuing of racketeering authorizations. And that decision was taken by the prosecution team with the exclusion of Advocate Chauke.
Yes. Thank you.
Counsel, I interrupted you because you are talking about their delegated powers, among others, to litigate. That's where.
Yes,
asked this
I was
question.
going to show you that specific paragraph. So if you go back to 1A stroke 151,
Say again, Counsel.
if you go back to 1A stroke 151 at GSM 4,
I'm there, Counsel.
yes. So if you look at the last paragraph, among the terms of your delegation, so you are given the delegation to exercise powers under Section 20 of the Act, but the more important one for the purposes of the review and the appeal is the last delegation. Can you confirm what that delegation says?
Indeed, Chairperson. It says, and to act on behalf of the state in any appeal, review, or other applications arising from such criminal proceedings within the province of KwaZulu-Natal, subject to the prosecution policy of the NPA and any other directive of the National Director.
Yes. So the actual powers to oppose the application fell with you, who holds a position even below that of Advocate Chauke.
Indeed, Chairperson.
Yes. And the same, if you go to the second authorization of Advocate Matenjo, which is a page later, 1A152, he also has delegated powers to oppose review proceedings and to institute appeals.
Indeed, Chairperson.
And that is then confirmed. Who was Marty van Wyk? The name that appears at 1A153. Sorry, I think that seems to have
the
been...
next page.
Yes, the following page, yes.
Okay.
That seems to be a PA, if I'm not mistaken.
Yes, Marty van Wyk was the PA to the DPP of the Northwest.
Yes.
We are now at GSM 5.
GSM 5,
5.
Madam Chair, yes. Sorry, yes.
She acted at both the PA of the DPP as well as the PA of the chief prosecutor.
Yes. But the point there, if you look at the content of that email, is Mr. Smith is telling Advocate Jiba the following: I am informed by Advocate Mayema that you have decided that he must be part of the team that will handle the Cato Manor case in KZN. Okay? He is not very clear as to what his role should be, and has indicated to me that he would only be required to attend the initial planning sessions to help in putting together a plan of action and help in ensuring that all the agencies appreciate and understand their role in the operation, provide guidance and advice from time to time regarding the investigation and prosecution. He would not be required to read the dockets and prepare the indictment and to do the prosecution. All his traveling and accommodation would not be carried by my office. In order for us to clearly understand his working relationship with the rest of the team and to understand what he would be required of him and indirectly of me as the head office, kindly confirm or correct our above-mentioned perceptions so that we at least could have some kind of MOU. It looks like at the beginning it was presented in a very vague way because at a later stage, in fact, you played more than what was initially described.
In fact, at the beginning, because Advocate Matenjo is a deputy, I am a deputy. That was my understanding of what my role would be. But when there is a letter that was written by Jackie Lipinga, because I wanted to find out exactly what my role would be, because I thought Advocate Matenjo and I are on the same level. I mean, until I was told that you are the lead prosecutor.
Yes.
And you will do prosecution, you'll do everything what is contained in your delegation, and not the things that are in GSM, where is that email of Advocate Smith?
Can you look at 1A stroke 150?
150.
GSM 3.
Yes. GSM 3 was a communication from
I mean, you said it was written by Jackie Lepinka.
Yes, from
That's
the
what
office of the National Director.
Yes.
Because I had communicated my uncertainty with the role that I'm expected to be playing. When then I was told in no uncertain terms that my role will be determined by the events as the matter progress.
Yes.
This matter is a national project, and therefore the cooperation from all the relevant identified officials is important and should not be hampered, as it will have an impact on the said matter. Because at the initial beginning, I thought I would be able to continue with the matters that I was dealing with in the Northwest, and I will not be expected to deal with the prosecution decisions of those matters if they were to arise. But we were informed to the contrary that no, you will exercise powers that are in Section 24B, which is, dealing with those matters. If it's prosecution, you prosecute. If it's an appeal, you deal with it, which means your full prosecution might. You go and exercise it in KZN.
Yes. Yes, I mean, I suppose unlike an ordinary prosecutor, here you've got something more substantive because they're saying, if these people challenge this, oppose it. Don't come to me asking for permission.
Yes.
You've got the power.
Yes.
Yes.
In fact, what we did was, just as when we prosecute now, a prosecutor is expected, can be questioned, his authority to prosecute can be questioned at any time. So I'm expected to have my prosecution delegation and to show it to anyone who wants to see it, be it a member of the public. My authority to prosecute, when it's questioned, I should be able to show any person what my authority is.
Yes. Madam Chair, we finished the index, which hopefully would be useful in referring to the annexures. It contains the GSM reference and the page number. So perhaps those could be handed up.
Yes, Council, thank you.
Does the witness have? Mr. Maima, do you have the index?
I do have a
Oh,
copy.
sorry.
Council.
Okay,
Thank you.
I was waiting for you. Sorry. Okay.
My apologies.
No, that's fine. I didn't clearly comment.
I suppose this list will add up to the exhibit list that is now being prepared by Advocate Cato.
Yes, Madam Chair.
Your team or your juniors will work with her to make sure that there is a continuation from this list of annexures.
Yes, Madam Chair. Thank you. Mr. Ramokhal is in court and is listening. All right. So now can we move on to Cato Manor now? I think we've done enough scene setting. Okay.
Indeed.
From
Chairperson
Part
Hare.
B. Yes.
Yes,
Yeah,
yes.
okay. So take us through then paragraph 38 and 39 and 30 and 40. We'll deal with Colonel Ayer, but there you describe the command structure of the Cato Manor unit, the so-called Cato Manor unit.
Yes, yes.
Yes. Chairperson,
Insofar as Cato Manor is involved, we considered we looked at a number of case dockets of incidents which occurred during the period 2006 to 2007 involving the Cato Manor Serious Violence Crime Unit, which was headed by General Johan Boysen, who was then holding the rank of a brigadier. And he served as a director of that unit. Although the formal designation of the unit changed from time to time, for operational purposes, functional purposes, it remained essentially the same entity. And I'm saying this, Chairperson, because in 2006, in 2010, the concept of organized crime was introduced, where there was a specific focus now on organized crime. And what happened then from 2007 to 2010 was that Cato Manor SVC, serious violent crime, became part of this new established organized crime unit. This organized crime unit was introduced in all the provinces. In the Northwest, in Gauteng, all the provinces had organized crime units. And they had heads they had provincial heads of those organized crime. In KZN, the General Johan Boysen became the provincial head of organized crime. In the Northwest, General Mabula became the provincial head of organized crime.
Yes. And then in paragraph 40, you refer to the command structure, which is annexed as GSM 1A to 140.
Chairperson, if you look at GSM 1, if I can have a look at it. Chairperson, if you look right in the center of GSM 1.
1A to 140.
On GSM 1, right at the center there. Or let's say it's headed Provincial Organized Crime Organogram in KZN. Now, the provincial commander there on top would be General Johan Boysen.
Advocate Ngcukaitobi, I can hardly see, irrespective of my double lens.
Madam Chair,
Can see what
yes.
is here?
Yes.
Chairperson, I can see
perhaps
it because
let's-
I worked on a copy that was more legible than this.
No, I think perhaps what we should do is to try and find a more readable copy, because I can see, but there are some parts that I also can't see.
Well, I can see all the parts. Provincial Commander, Organized Crime, KZN. Because I have worked on this matter. I have seen this document
Yes, we
before.
are not quibbling with that,
Yes.
Advocate Mayema. We need to have documents, because when we present this report to the President, you won't be there to explain to him. So we must have legible copies, at
Indeed,
least.
Chairperson.
Or this document can be re-prepared. I don't know. Can you just get a clearer copy? Is it possible to get a clearer copy or read it into the record?
Yes.
If you can read everything here,
I-
from Provincial Commander Organized Crime, KZN, and read what is below that, I see Boysen's there.
All right.
Maybe for now.
Maybe you can take him through the document.
Yes, I think for now, then let's try and do it the hard way. We will try and find a better copy at a later stage. All right. What is this document we're looking at GSM 1?
GSM 1 is a provincial organogram of organized crime in KZN.
Yes, all right. And then do you know its origins, where it was produced?
It's a document that we obtained that was in the command structures in KZN.
But it was produced from the SAPS itself?
From the SAPS itself, yes.
All right, okay. Now, in the middle top, it's written Provincial Commander, Organized Crime KZN, Director J.W. Boysen. Is that
Yes,
correct?
that is
Okay.
correct.
And what is that designation for?
What it tells us is that General Johan Boysen, when organized crime was introduced in 2010,
Yes.
yeah, he then became the provincial head, provincial commander of organized crime in KZN. That's the name that is not visible there, Director J.W. Boysen, it's the portfolio that he's holding.
Yes. And then,
Underneath him, straight with an arrow, you see.
yes, there are two arrows. There's one arrow to the left. I suppose you can ignore that because it's for the secretary. That seems to be more of an admin role.
Indeed, Chairperson.
All right. And then there's a straight arrow, which is, let me just see, OCIUK, OCIU KwaZulu-Natal. Durban, Superintendent Aya, Peter Marisberg, Superintendent Lats, Richards Bay, Superintendent Mtembu, Port Shepstone, Superintendent Newswa, Asset Forfeiture, Superintendent Wakefield. Can you just explain what that is?
Chairperson, if one goes to page 11, paragraph 40 of my affidavit.
Okay. Yes, we are there.
This is the document that is referred to, the organogram of Provincial Organized Crime Unit. The Devon Organized Crime Unit fell under the now the Devon Organized Crime Unit would be if one looks at the what do you call this?
The square in the middle.
Square, yes,
Yes.
the square in the middle that has Director J.W. Boysen. There is an arrow directly underneath it
Yes.
that says OCI KwaZulu-Natal. That is Organized Crime Investigative Units in KwaZulu-Natal. Now, in paragraph 40, I spelled them out. It was Provincial Organized Crime Unit in KZN. That's the last but one line, comprised of Durban. Now, when you look at this square, the first on top there is Durban.
Yes.
And then the next will be, in the organogram, it says PMB. In my statement, it says Peter Marisberg. That was the second one. And then the third says Richards Bay, which I have mentioned it in the statement. Now, in the next line is Port Shepstone, and then lastly, Asset Forfeiture. So, Devon was under the command of Senior Superintendent Aya. Peter Marisberg was under the command of Senior Superintendent Lats. Richards Bay was under the command of Superintendent Mtembu. And Port Shepstone was under the command of Superintendent Newswa. Newswa as in NWUSWA.
All right. Now, just before we move from there back to your statement, I mean, is there anything in the organogram that is crucial other than to show that Director Boysen was directly overseeing organized crime in Durban?
Counsel you 100%. All it says is that Director Boysen was in control of all those organized crime units in Durban, Peter Marisberg, Richards Bay, Port Shepstone, and the Asset Forfeiture, which were headed by Durban, Sup Aya, Peter Marisberg, Sup Lats, as I have noted in paragraph 40 of my statement.
And the arrow on the left and the right, for the current purposes, we can ignore them.
Yes, because on my left, it would be policy,
Yes.
and on the right, it would be something else. But operationally and effectively, the unit is the one in the center.
Yes. Well, there are two that are two squares that are important. It's the top and the center.
The top and the center, Council.
All right. Thank you very much. Now we come back then to your paragraph 40. Is there anything you wish, because there's still the last sentence there that is crucial that you haven't touched upon?
Within each of these units were various sections. One such section, a small and tightly knit group officers stationed at Cato Manor, which was referred to as a Cato Manor SVC, Cato Manor Serious Violent Crime.
So do you want to explain what that means?
Now, when organized crime was introduced in 2010, as I outlined in paragraph 39, the Cato Manor Serious Violent Crime it was introduced to deal with the serious organized crime in the province.
Yes.
So the unit that was dealing with organized crime was this Cato Manor Serious Violent Crime ought to have been part of the Durban organized crime, which was under the command of Senior Superintendent Aya.
Yes.
Senior Superintendent Aya, who is mentioned in
Paragraph 41.
In paragraph 41, yes, just there. Yes.
Yes. All right. So the point is that there is the provincial organized crime.
Yes.
Under it, there is the Durban organized crime, which is led by Colonel Aya.
Colonel Aya, yes.
And then under Colonel Aya is...
You have section commanders.
And then who, according to your statement?
Now, those section commanders are Colonel Olivier.
Yes.
Now, Colonel Olivier Olivier
Yes.
is a person that I refer to. Chairperson, can I ask to refer to them when I refer to the indictments as accused 9, knowing full well that the matter has been withdrawn and they are not accused
Maybe
persons?
you can just deal step by step with what counsel is dealing with now. He's dealing with 41.
Yes.
He's trying to look at those people who were under the command of Colonel Aya.
The people who are under the command of Colonel Aya was Colonel Olivier, the section commander. Colonel Olivier was supposed to report to Colonel Aya.
Yes. All right. So what we know, at least from the structure you've depicted, is you've got Mr. Poison at the top.
Yes.
And then you have Mr. Aya or Colonel Aya.
Yes.
And then you have Mr. Olivier, Lieutenant Colonel Olivier.
As a section commander.
In that chain of command.
Yes.
Yes. All right. Thank you very much. Okay. So then you mentioned, we can skip the rest of paragraph 41. I don't think it touches upon. We're still laying the structural foundation.
Yes.
At paragraph 42, you mentioned there that over time these sections changed, but that core group remained unchanged. Can you just explain that?
The core group, that means the core member of Cato Manor SVC,
Yes.
it remained the same,
Yes.
despite the changes that were referred to. Remember, I referred to 2010 when organized crime was introduced. This member of Cato Manor SVC, they literally just remain the same, which means in police terms, when you deal with serious violent crime, when I'm paired with Advocate Ngcukaitobi, for example, he should be somebody that I have worked with, that I trust with my life, because serious violent crime is serious violence crime and it can take your life. So when I'm paired with a particular individual, is an individual that I should be able to bet my life with. Should say, if an incident arises and my life will be at stake, he will cover for me. I'll do the same for him. Which means if you are in an instance of, Chairperson, say, a bank robbery, and attackers fire at the police who are trying to arrest them. And Officer A works with Officer B. Officer B must be confident that Officer A will protect his life with his own life. Must be confident that I can bet my life on my partner.
Yes. I mean, for the purposes that we are dealing with, the continuity, despite the changes, includes two facets. One is that General Boysen was promoted to the province.
Yes.
That's the change.
Yes.
The second is that a new unit or a new provincial unit, organized crime, was created.
Indeed.
But that didn't affect the people that actually occupied the positions at Cato Manor. Except, of course, Mr. Boysen had to be replaced, and we know he was replaced by Colonel Aya.
Indeed, Chairperson, what happened is, despite General Boysen being in the province now as a provincial commander, and Cato Manor, which was part of organized crime in Durban, having to report under Superintendent Aya. Superintendent Aya was rendered redundant, and General Johan Boysen continued making Superintendent Aya redundant and leading the Durban organized crime, leading these members of the Cato Manor SVC.
Yes. So that's the continuity you are talking about.
That's the continuity, yes.
Thank you. Now, if we can then move to paragraph 43, because there you are distinguishing now the people that were de facto managers from those that were participants. We are beginning to do the foundation of the charge, but let's start with who you've identified there as holding managerial or command positions.
Now, for the purpose of poker,
Yes.
certain members of the Cato Manor SVC occupied managerial or command positions within this group. I mentioned that Colonel Aya was rendered redundant. So General Boysen replaced him, although being in the province, but then he continued having a close relation with Colonel Olivier, Neville Eva, who has now passed, may his soul rest in peace, accused 15 Anton Lochem, and Eugene Van Tonder. So those were the people that were occupying the managerial positions within Cato Manor SVC.
Yes. Now, we will deal with this later when we deal with the requirements of poker, but it might be a convenient time to just debunk one myth that has percolated the de Kock report, so-called, that you cannot just duplicate. That is what they say. I'm not saying they're correct. Duplicate the formal structure and say that constitutes management of the enterprise. How did you see it as the lead prosecutor?
Well, as a prosecution team, we saw General Johan Boysen, although he has to be as the provincial commander in the province and not in Durban organized crime or in serious violent crime. We saw him rendering Aya redundant and taking over what Aya is supposed to be doing. What is instead of the commanders reporting to Aya, they report to him. And the core managers then were Olivier, Lieutenant Colonel Olivier, Captain Eva, Captain Lochem, and Captain Van Tonder. So all of them, instead of reporting to Aya, then they reported to General Boysen, as if General Boysen was the unit commander. So instead of being the provincial commander, he then doubles up as provincial commander and as unit commander, rendering AIA redundant.
Yes. So the accusation that all you did was just to take the formal structure and to substitute it for an enterprise. Is that?
No.
Yes.
What you did is we looked at the activities of the unit, what actually happened.
Yes.
And we saw that, for instance, when an incident happens, Lieutenant Colonel Olivier, Captain Eva, all the managers
Yes.
would then inform General Boysen instead of informing their unit head, who's supposed to be Colonel Aya. So incident will happen without Aya's knowledge, but with the full knowledge of General Boysen, full knowledge and support of General Boysen.
Yes. So in sum, you regarded them as de facto in management of the enterprise.
We consider them as a de facto managers of the enterprise.
And then the balance were then participants.
The balance were then participants in terms of Section 21F.
Yes, thank you very much. Now, in the following page, at paragraph 44, you give the context to these events, and you start with the taxi conflict between Stenga Taxi Association and KwaMaphumulo Taxi Association. Can you just outline that background?
Thank you, Chairperson. Superintendent Kongo was a member of the taxi violence task team in KZN. He investigated taxi violence killings in KZN. There was a continuous feud between the Stenga Taxi Association and the KwaMaphumulo Taxi Association that he was investigating. And then he would from time to time then transport those accused persons or take those dockets to court and take those accused persons to court together with his team. Now on the paragraph 45, on the 27th of August, Sub Kongo was taking...
27th August 2008, just also announced it.
Oh, yes. 27 August 2008, Superintendent Kongo was taking accused persons to court when an ambush happened. Superintendent Kongo was in a company of Inspector Kanyile, together with others. What happened there was there were roadblocks. The road was being refurbished. The result was that the vehicles, when they arrived, they had to slow down. Now, at that time where they slowed down was the time when shots were fired at the two vehicles that were transporting the accused persons to court. But from the members of the investigation team that saw the car in which Superintendent Kongo was traveling, the concentration of the shots were fired at the vehicle in which he was traveling. That's why you see him then dying at the scene of the shooting. And Inspector Kanyile, who was in a different car with the accused persons, was injured but survived. So what happened then was Cato Manor Serious Violence Crime Unit then followed up, analyzed the information that they procured from that scene, and followed up on the killing of Superintendent Kongo. Chairperson, I must just mention that when this incident happened on 27 August, 2 other police officers had been killed. Superintendent Govender had been killed, and Nkosi Zondi was killed.
Was
Was this in the same incident?
No. Different incidents. What I'm saying is that Nkosi Zondi was killed. Nkosi Zondi was a member of Cato Manor unit. Was killed in a separate incident. Subgovenda was killed in a separate incident. But now,
look,
when
Nkosi Zondi was killed on the 22nd of January 2008, and Superintendent Ngcukaitobi was killed on the 27th of August 2008.
yes,
Yeah, so there is at least about a year in between the killing. But let's just concentrate on the killing of Superintendent Ngcukaitobi. That's where we are right now. We will come back to Nkosi Zondi.
okay. Now, what happened then was when Subkongo was then shot at and killed, Cato Manor SVC felt enough is enough. You cannot have men in blue killed in the manner that are being killed by thugs. Criminality is taking over. They felt they must follow information that they collected from the scene of Subkongo's killing. So, paragraph 46, following the shooting of Subkongo, members of Cato Manor SVC then targeted individuals that they suspected of involvement in his killing. And then the pattern that emerged from there was anybody that they suspected of involvement was raided. And all of these incidents, we see them happening after the killing of Subkongo, which gave us the impression that Cato Manor said, enough is enough. Criminals are not going to take over. We will deal with this criminality in KZN. And dealing with criminality in terms of the law means arresting them and bringing them before courts of law, for courts of law to determine their guilt or otherwise. But what we saw happening after the killing of Subkongo was Cato Manor went on a rampage of raiding suspects or people that they suspected of involvement in taxi violence or in the killing of Subkongo, and killing all of them.
Yes. Could I just ask you on this point, this idea about the killing of Superintendent Ngcukaitobi? The one view is that it was used as cover for the elimination of KwaMaphumulo, members of the KwaMaphumulo Taxi Association. We've asked for this docket. We haven't seen it. The promise is that it will be made available so that we can actually see what happened in the investigation of Superintendent Ngcukaitobi. From your point of view as the investigators, as the prosecutors in the team, I mean, were you given access to the docket of the murder of Superintendent Ngcukaitobi?
Chairperson, we asked for this docket.
Yes.
It never came forth.
Yes.
We asked to speak to, the investigators asked to see Inspector Kanyile, who had survived the ambush. So far, we haven't seen a statement that he had made. At the time that we were dealing with this matter, he was hospitalized. And a statement has never been obtained from Inspector Kanyile.
Yes. So it remained an open question as to whether the Cato Manor unit had any legitimate basis to connect anyone to the murder of Superintendent Ngcukaitobi.
Indeed, Chairperson. In fact, Subkongo in KZN, the witnesses that we consulted with said he was a stray cop. he was dealing things in the right manner, taking accused persons to court. And there was a view at some stage that Cato Manor would have been jealous of the successes that he was having in Cato Manor, in dealing with, in quelling taxi violence in KZN.
Yes, well, there is a statement, but we'll deal with that, that actually says, in fact, even Cato Manor could have had a role in the elimination of Superintendent Kongo.
Indeed.
Madam Chair, without being seen to be intrusive,
Please speak to that mic and speak loud.
Yes, without interrupting Advocate Ngcukaitobi's leading of evidence, but perhaps one should be reminded that he is leading the witness in chief. He's not cross-examining the witness. And therefore, he should be testifying through the witness and not put the evidence to the witness for the witness to testify. If, for example, he wants to put a particular point, maybe he should draw the witness's attention to that point and let the witness tell us in his own words and not in Advocate Ngcukaitobi's words as to what conclusions and what were the propositions. Because it's his witness, it's not the cross-examining the witness. If it was cross-examination, we would accept that, but it's his evidence, it's his witness, and the witness is in chief.
Are you suggesting that Advocate Nkcukaitobi is coaching the witness?
He is leading the witness, he's leading the witness per se. Not that he's coaching the witness, but he's leading the witness. He should be asking the witness his questions and not put propositions to the witness for the witness to just confirm.
Advocate Nkcukaitobi?
My learned friend must point out to the question that he's objecting to. What is unacceptable is for him to make a generic statement. If he's got a question that I have asked that is leading, he must tell me what that question is.
For example, the latest question that he just asked about the matter of Congo, that in fact the proposition is that the matter of Congo was used as a cover-up by the Cato Manor squad to eliminate members of the Wamapumulo Taxi Association. The witness had not told us that. He's the one telling the witness, and the witness simply agrees with him. He should perhaps point the witness to that evidence and get the witness to tell us in his own words as to whether what was the witness's interpretation of that evidence. Remember, the witness is here to tell us that he's the one who studied the documents and it is the evidence that he considered. I'm sure whatever proposition that Advocate Nkcukaitobi wants the witness to say, the witness can say it himself.
I thought, subject to correction, I thought Advocate Nkcukaitobi was saying there are allegations that this was a cover-up, something to that effect. Did you understand him to say that?
But then the witness simply agrees with him. If there are allegations, if there's any evidence led, he should maybe draw the witness' attention and say, look, there's this evidence. What is your comment on that? Instead of saying, there is evidence that this is just a cover-up, and the witness says yes. The witness does not know what evidence is that.
If I may, do you know of anything that counters what he says as you are objecting?
We're not objecting to the evidence per se, but the manner in which the evidence is being sought to be extracted from the witness. That's what we're asking him to do. That if there's evidence that, for example, if there's a document in the bundle that seeks to support that proposition, let him go to that document and say, this is the evidence. What is your comment on that? Let the witness speak for himself.
Yes, Advocate Mtweni, sometimes the procedures under the inquiry, bearing in mind your role, this is not a criminal prosecution. Your role as evidence leaders is to assist us. I'm not sure as you object with a view to protect who or what?
No, Madam Chair, we're not seeking to protect. We're just saying that it's part of our role to make sure that the evidence comes out not propositions from Advocate Ngcukaitobi. If there's evidence that Advocate Ngcukaitobi wants to point out, let him point out that evidence and not let him put conclusions to that witness. That is the premise from which we're asking him to do.
Now, the evidence that he was referring to, or allegations of a cover-up, that's where your uneasiness is?
Yes, because what we're asking is that if there's that evidence, let him show the witness, here's a statement by a witness who says, or if there's going to be evidence later on, at least let him preface that to say, I will take you to a statement that says this was the cover-up, so that the witness can at least be able to comment on that, on the basis of tangible evidence.
Yes.
We're not seeking to prevent any evidence from coming out, Madam Chair. We want that evidence to come out.
Advocate Nkcukaitobi.
Madam Chair, with the greatest of respect, I mean, firstly, my learned friend is just wrong when he says that the witness confirmed. The witness didn't confirm. I said the allegations are that this was used as a cover for the killing of Superintendent Chauke. The person who gave that evidence is Advocate Noko. Everyone was here. Now, does he want me to go to the transcript and say this is where Advocate Noko says? This is a waste of everyone's time. There is a statement at page 1A/179, GSM 8, by Begingosi Mtiani Dlondlo. And you can go to page 1A/180, which says exactly what the witness has just said. This was a straightforward cop who didn't take favors, and the suspicion was that the reason he was killed, it was to eliminate him. Do you want to go through to that? Maybe that will simplify all of this.
What paragraph are you reading?
I am now at, so if you could, thank you, Madam Chair, if you could go to GSM 8 1A/179. So that's where the statement of Dlondlo starts. But he then discusses Chauke specifically at 1A/180. Yes. And 1A/181. Yes, he says the cause of Mr. Chauke's, paragraph 7, the cause of Mr. Chauke's death was that he was investigating and arrested Maphumulo Tax Association members. Mr. Chauke was killed by a Maphumulo Tax Association. Nkosi Zondi was a policeman working for Cato Manor unit. Information was taken to Nkosi Zondi, and Nkosi Zondi arranged with his unit, Cato Manor, and also poisons his commander. I mean, this has been here since we began, so this objection is a waste of everyone's time. Do you want to comment on that? I mean, they were saying I should give you the actual statement, which is there, so maybe you can comment then.
My understanding, Council, is we are starting to build up.
Yes.
My understanding, Council,
Just deal with the statement. Don't make the argument for me. I've made the argument. You know. So.
Thank you, Council. Thank you, Chairperson. Yes, the statement of Begingosi Mtiani, who was referred to as Dlondlo, is the statement that tells us what happened. His perspective of Superintendent Chauke's killing. If one looks at paragraph 7, it specifically deals with his view of Superintendent Chauke's killing. The cause of, he says, Mr. Chauke.
I've read it to the record, but
yes.
I just wanted to make sure that there is a statement there. This thing is not made up by me.
Yes, as well as Nkosi Zondi. His name is also mentioned in the same paragraph.
Exactly. Thank you. Let's move on then back to your statement.
Before you do that, we are still on the objection.
Yes.
Council seemed to be concerned about what you said was an allegation of a cover-up. Am I correct?
Madam Chair, I think the manner in which you just asked the question clarified it, because the proposition you made to the witness was that there was a cover-up. So what we wanted was let him point the witness to that evidence, and EJ has just addressed it. So that deals with our concern.
So the objection cannot be sustained.
Not after what Advocate Nkcukaitobi has done, Madam Chair.
Yes, thank you.
Thank you, Madam Chair. I may proceed then. I think, yes, thank you. All right. Now you then, we were at paragraph 47. So we've addressed that Congo is the alleged trigger, but we know what the witnesses subsequently told you.
Yes.
And then, well, Superintendent Congo is the alleged trigger.
Yes.
And then from paragraph 47, you refer to media reports.
Chairperson, just before this last aspect escapes me, in paragraph 46, six persons as at that date were killed, and one will see that in the indictment, and the 6 persons that had already been killed at that time would include Lindelani Buthelezi in Kwadukuza case 39 of 9 of 2008, Magojela Ndimande, as well as Sbusiso Tokozani Tembe in Howick case 106 of 9 of 2008. On the 18th of September, Nzameni Johannes Ntuli, who was generally there called Kopolota, as well as Nkosinati Wilson Ntembu, and the 7th person would then be Mdum Kize.
Is that 6 or 7?
6.
Yes, okay.
So 6 persons would have already been killed. But what I wanted to say is 5 are members of the taxi association, whereas 1 was a bodyguard. Tembe was a bodyguard.
Yes, Mr. Tembe was a bodyguard of Mr. Ndimande.
He was a bodyguard of Mr. Ndimande. They were killed together on the Howick, on the N3 Howick freeway towards Johannesburg.
And the names of these people that you have read into the record now or mentioned them, where are you reading them from?
Chairperson, I'm reading them from the indictment, from the summary of substantive facts.
Please take us there. When you move from your affidavit and you go to another document, alert Advocate Nkcukaitobi that you are now referring to a document so that we can go to that document.
What might work for you is perhaps to look at GSM 75. If you want to do that exercise, which is 1A711 in file 3. Um, 711. Yes. Yes, that's the prosecution memo. So GSM 75, and then you can go then to the names you wanted to mention.
Chairperson, GSM 75, paragraph 3 mentioned killings and lawful activities which were
And if you
Which
look
were-
specifically at 1A712 under paragraph 5.
Yes. The names that I had mentioned are the names that are in the prosecution memo GSM 75. The very same names are also in the indictment. These names of the deceased who are in the indictment. In paragraph 5, Chairperson, the taxi violence killings are directly related to the killing of Superintendent Khono, Zetembe Mawakile Khono, and the killing of Inkosi Wellington Zondi. Superintendent Khono was a coordinator dealing with the taxi violence killing between KwaMaphumulo Taxi Association and Stenger Taxi Association. He was killed whilst transporting prisoners to court, or accused persons to court, on the 27th of August, 2008. Certain members of KwaMaphumulo Taxi associations, and I will mention those names, were suspected of having a role in the killing of Superintendent Khono, and were subsequently tracked and killed from 3 September 2008 to 18 October 2008. And this is the subject of the dockets that are referred to in the table. We refer to an incident on the 3rd of September 2008. The docket reference number is Kwadukuza case 39/9 of 2008, is the killing of Lindelani Buthelezi. On the 16th of September 2008, docket reference number being Howie case 106 of September 2008, where Magojela Timson Ndimande, as well as a bodyguard, both Lindelani Buthelezi and Magojela Ndimande are taxi owners. Now, Sbusiso Tokozani Tembe was the bodyguard to Ndimande, who was the vice chairperson of Stenger Taxi Association. On the 18th of September, in
This GSM 75 is your prosecution memo.
indeed,
But,
Chairperson.
what's the date in this memo? If you look at a conclusion at B01062, I don't know what is the right numbering, Advocate Ngcukaitobi. But at the end of that document, this is your prosecution memo, am I correct? Or is it something else? I see the fonts are different.
Oh, yes. Madam Chair, if you go to what page? Of the statement, of paragraph 397 of the statement, of the witness statement. 397 at page 104, 1-104. So that's the reference to GSM 75.
The date is
15, 20,
the
2012,
date is
yes.
15 August 2012.
Yes.
Does not appear on the memo itself.
Yes, I looked at that. You're correct.
Yes, thank you.
Thank you, Madam Chair. I am going back to my... Yeah, no, paragraph. Huh? No, we were at paragraph 46. Thank you. You remember where we started? The chairperson wanted to know the 6 names you were reading. Where were you reading them from? You've confirmed that they are at 1A711, 712 actually,
Indeed,
under paragraph 5.
Yes.
Yes, all right. Thank you. And that is a prosecution memorandum that you prepared on the
15th of August.
of
20.
August 2012.
Yes.
All right. And those are killings related, allegedly, to the murder of Superintendent Tonto.
Yes, those are the killings of people that were suspected to have been involved in the killing of Subtono, who were then tracked and traced by the Cato Manor SVC.
Yes, all right, good. Yes, we were just about to start the issue of the media reports at paragraph 47.
Chairperson, can I also mention that these names are subject of the indictment? So the names of the deceased in the prosecution memo would be the deceased that are mentioned in the indictment.
In the indictment, in respect of the dockets or the cases against those accused people in the Cato Manor cases.
Indeed, Chairperson, yes.
Okay.
So in the indictment, I will also refer you to these very same names. In fact, right now I can tell you, Lindelani was a deceased in which count, and yes.
Yes.
But I haven't been asked that question.
No, not yet. It's coming. All right. So the article that is referenced at paragraph 47 is GSM 2, which you will find at 1A/141. Is that correct?
1A stroke
141.
141. It's the different file. 141. I'm there, Counsel.
Can you confirm, is that what is referred to at paragraph 47?
Yes, at paragraph 47, when I refer to media reports, this is the media report that I'm.
And that media report is a report by the Sunday Times of the 11th of December 2011, a report by the journalists Stefan Hofstadter, Mzilikazi wa Africa, and Rob Rose. Is that correct?
That is correct, Chairperson. And this is the this article that caused a real outcry within the community. You can see from the shoot to kill that it wasn't sending a good message.
Yes, and that 1A/142, it's apparent that the journalist had access to the photos, which subsequently became used in the docket.
Indeed, Chairperson.
Yes.
Now on 142A,
Yes.
I think it's important, in the center of the picture there is there are two vehicles there.
Yes. So that's 1A/142.
1A/142.
Okay.
There are two vehicles there, the center of the.
Is that
of the
the picture where there are two
picture.
gentlemen shaking hands?
Yeah, the two gentlemen that are shaking hands. One of them is General Boyce, the one in a blue jacket.
Okay.
All these documents that follow after the initial documentation 2 at 1A/141. Beg your pardon. All these documents following GSM 2 at 1A-141 are part of that annexure. It's a bundle of documents forming part of that annexure.
That seems to be the case, Madam Chair, because if you look at the top, they are all 11 December 2011.
Yes, and they're all one capital A, and then subsequent numbering.
Yes, yes, Madam Chair.
Should we assume or accept that they are all part of that annexure GSM 2?
Yes. Well, do you want to confirm, Mr.?
I confirm. I confirm they are part. I confirm they are part.
You should
Chairperson.
please confirm Advocate Mutswene will take
Yes,
you to task. Yes.
apparently.
Chairperson,
Madam
if I can
Chair,
just mention-
I've learned the hard way. I'll never do it again.
I beg your pardon, Counsel.
I will never do it again.
No, you're within your right, Counsel, to object if you do not follow something. We are all here to make sure we are doing the right thing. Yes, so this bundle, the 1As, capital A's, are all forming part of that GSM2. I see in
No, there
in
is.
the list, it is up to 1A up to 149. I think that is correct.
Yes, because
Yes,
there is
before-
a different.
Before GSMA 3. You see the list
Yes,
of
yes.
annexures you gave us?
Yes, that's correct.
It seems to confirm that, Counsel.
Yes.
Yes, so we'll just deal with those as forming part of the bundle
Okay.
before GSM M3.
Yes.
I'm sorry with my irritating voice.
I confirm, Chairperson, that is my understanding.
All right. Thank you. Yes, the only thing that seems to be different.
And when I interrupted, you had just gone to the next page, 1 cap A, N dash or dash 142.
142,
And then you
yes.
referred to those pictures and the vehicles there.
Yes,
I missed the point.
I think the witness was drawing our attention to the picture in the middle of the page. Perhaps you should start from there, Advocate Mayema.
Chairperson, what I was saying, the picture in the middle, we see two vehicles there. The one in a blue light, that would be the police vehicle, and the silver,
The one in the front.
the one in the front.
Okay.
The silver vehicle, it would be the Hyundai Tucson that was driven on the 16th of September 2008. As I look at A1-712 of the prosecution memo. That is the vehicle that is the grey Tucson is a vehicle that was driven on the 16th of September 2008, incident Howick case 106 of 9 of 2008. It was driven by the deputy chairperson of the Stenger Taxi Association, Makojela Timson Dimande, as well as his bodyguard, Sbusiso Tokozani Tembe. That was the vehicle they were traveling in. Chairperson, if you look,
Take me to that paragraph in the memorandum that you've just been referring to.
Chairperson, I said on GSM 75,
Yes.
on page, it starts at A1-711.
That's it?
It starts at GSM 75.
Yes.
It starts at A1-711.
Maybe just give me the page number in there.
The page number is A1-712.
712.
Just the next page.
Yes.
There is a table, Chairperson, there
Yes.
with dates, docket reference number, name of deceased.
Yes, thank you.
Now, what I just said was that this vehicle, the grey Tucson, you won't see the registration number, but I know it because I worked on this matter. It's an NRB registration. It was a vehicle that was driven by Timson Magojela Timson Dimande and Sbusiso Tokozani Tembe on the 16th of September 2008. And that one sees on GSM 75 on page A1712 in the table there, Chairperson. The second incident on the 16th of September 2008.
Yes. Yes, thank you.
Thank you. I think just to correct yourself, the people that were targeted on the thesis of the prosecution were Kwamaphumulo, not Stenger.
Or did I say? Oh no,
Yes,
Kwama
no,
Phumulo
Stenger
Taxi
yes,
Association.
yes, exactly.
The Stenger were the people that were financing,
Yes.
that were colluding with Cato Manor to,
Yes.
to.
Yes, so there's no way that Mr. Ndimande could have been the vice chairperson of Stenger.
No. It's Kwama Phumulo. I wasn't hearing myself.
Yes, all right, that's fine. Now, we just go back to the article, that page you were looking at, which is the 1A142.
I'm there, Chairperson.
Yes. Is there anything you want to add on what you've just been describing, that the Major General Poison is there at the crime scene? There is a vehicle there that was driven by Mr. Ndimande and Mr. Tembe. The date is the 16th of September 2008.
I confirm, Chairperson.
I'm saying, is there anything, I'm just repeating what you've said, but is there anything you want to add on top of what you've said?
Chairperson, if you look behind the vehicle, behind the Tucson, the silver grey Tucson.
Yeah, there's a dead body, well, an apparently dead body. I don't know if
Yes,
it's dead.
there is the dead body. And the vehicle that one sees in the blue light would be the police vehicle that was pursuing the Hyundai Tucson that was being driven out of Pietermaritzburg. This incident.
There's a body lying behind that grey vehicle. Tell us about it.
Chairperson, there are doors on the right hand side of a vehicle. At the back, there is a rear door which is opened. Now, if one looks at there's a driver's door and there's a passenger door. Underneath the passenger door, there is a body of a person lying there. That was the bodyguard.
The bodyguard was
Is
Mr.
that
Tembe.
underneath the passenger door or at the rear of the vehicle?
On the picture, you see it underneath the door, but it's at the rear of the
Yes, because there's a tire there.
Yeah, there's a tire.
There's a back tire there.
There's a beige, something that looks with a beige covered with something beige. That is the body of Sibusiso Thokozani Tembe.
So that body is at the back of the vehicle.
It's at the back of the vehicle.
Yes.
Chairperson, we will show you pictures where where this body can be seen.
Yeah, no, it's not. I just want, you said that the body is under the passenger door, so I just wanted to make sure that I understand that.
It is actually at the rear of the vehicle.
Yes.
Yes.
The depiction makes that very clear.
Yes.
The two gentlemen who appear there, do you know them? The two gentlemen who appear on this picture, do you know any one of them?
The gentleman in a blue jacket with beige pants, that is General Johan Boysen.
That is the gentleman wearing a police vest.
Yes, and the one wearing the one in a white shirt. Chairperson, here I will speak under correction because then I would need to look at the lineup. But my recollection says it's Colonel.
Please, if you're not sure, you can defer your answer. Unless, of course, you are sure about that.
It's a police officer that came in a helicopter with General Johan Boysen. His name is in a statement later.
Okay, well, even the article just identifies General Boysen.
Oh yes, the article in fact says Major General Boysen, head of the Hawks in KZN, on the right in the picture. Yes, arrived by police helicopter at the scene of one of the killings. So this is the scene of the killing of Magojela Timson Ndimande and Sibusiso Tokozani Tembe on the 16th of September 2006 on the N3 highway between just after Howick on the freeway.
Yes, we asked these questions because you only got the statements and the documents this morning, just as the evidence leaders. So we will ask you to clarify. I didn't see this recorder
Indeed, Chair.
in fine print, but I see they explain who this gentleman are.
Yes,
Yes, thank you.
thank you, Madam Chair. If you can go to the...
It is 1:45. Advocate Nkcukaitobi.
yes.
Are we moving at a snail's pace? I even forget the time.
Yes, I think we are moving at a detailed pace. I'm happy to adjourn, Madam Chair, for lunch.
We promised you to adjourn for an hour for lunch, but if you like, we can adjourn for 45 minutes. Advocate Mchwene.
Madam Chair, would any time the panel proposes will be fine with us. Even 10 minutes will be fine with us.
Advocate Hale, are you happy with 45 minutes? 1 hour?
I prefer to have an hour.
An hour.
There's certain matters that I have to attend to unrelated to this, and I still need to look into some of the issues that Advocate Nkcukaitobi raised, or is going to raise.
Yes. We, Advocate Nkcukaitobi, we promised you 1 hour this morning
Yes.
for lunch.
Yeah.
Perhaps you should adjourn for 1 hour, which will take us to, it's now 1:45, 2:45.
Thank you, Madam Chair. We would also appreciate an hour, like Mr. Hale.
Yes.
Yes.
And you might look in also, just Castrolly will go through the application that he filed this morning.
Yes.
Yes, thank you. We'll adjourn until 2:45.
Thank you.
We adjourn. Remember, you are still under oath, Counsel.
I do, Chairperson, thank you.
Yes, thank you.
Qhubeka usisi lo oyi-senior investigator lo wakwaMasuku nokuthola ubufakazi bakhe lapha kwi-commission kaMadlanga. Ziningi izinto ezivelayo ezinye zibuhlungu ngoba kule video ngizokucaphelela noze wakhala inyembezi uma ekhuluma ukuthi impilo yakhe yakaba sengcupheni.
Yes, Ms.
Thank you, Chair. Ms. Masuku, we are now at page 14 of your statement. If you can't, please don't.
Mr. Law, let's take a break. You'll indicate to us when we should come back.
Absolutely. Thank you.